the topic of this session is the attitudes and the skills required for IP mediators. We will examine in depth the necessary competencies that the mediator should show in her or in his or her mediation practice. So the main elements of an ideal mediator should be confidentiality, independence and impartiality, flexibility and objectivity, active listening skills and asking open-ended questions, understanding human and business psychology, and also, of course, further development of these skills by continuous learning and continuous training. Based on this list, we will specify the necessary skills that the mediator should develop in order to demonstrate each one of these elements. It is important to start by saying that the elements a mediator should demonstrate are also reflected in the European Code of Conduct for Mediators. The code sets out a number of principles. It has been developed by stakeholders together with the assistance of the European Commission. It is intended to be applicable to all kinds of mediation related to civil and commercial matters, of course, including intellectual property matters. Here, there are two important points to stress. The institutions providing mediation can go further than the code and adopt more detailed provision, more detailed codes, and adapt this basic code of conduct to the types of mediation services the institutions offer, as well as to specific areas such as intellectual property. This is exactly the case of EUIPO that has taken the code and has further developed the provisions of the code, establishing its own regulatory framework, its own framework of rules, which of course also includes the provisions of the European Code of Conduct for Mediators. The second point that we should stress here is that the adherence to the European Code of Conduct for Mediation is without prejudice, of course, to national legislations on or other regulatory frameworks of different professions. This concretely means that the mediators should, apart from the Code of Conduct, of course, always respect the laws and the norms of the jurisdiction in which they operate. Let us now examine in detail the elements of our list that the mediator should demonstrate, and of course the relevant skills that he or she needs. Let's start with confidentiality. Confidentiality is a primordial element, a cornerstone of the mediation process. It is a duty established by the European Code of Mediators, but also it's a duty that has been established and further developed in the boards of appeal of EUIPO mediation rules. Additionally, our mediators, our internal mediators in EUIPO, since they are part of the internal staff, they are also covered, they are also obliged to respect confidentiality because of their status as employees of the EUIPO and because they are subject to our staff, internal staff regulation. So the duty of confidentiality in the context of a mediation is doublefold. What does this mean? This means that, first of all, on the one hand, it consists on the prohibition of disclosing any information that is disclosed in confidence to the mediators by one of the parties to the other without permission. So the mediator should not transfer information from one party to the other without permission. This is the first aspect. The second aspect is that it also covers the prohibition of in general of sharing information regarding mediation, covering also this prohibition regarding third parties. So, to put it concretely, the mediator cannot be a witness in litigation, on arbitration, on other formal process in connection with the dispute and in connection with the mediation. And of course, at the end of a mediation, the mediator should destroy any material that has been obtained for the purpose of mediation after the termination of this process. Which is considered to be confidential information. Confidential information is considered to be everything that has to do with the mediation. So even the request of one party to enter mediation is a confidential information and therefore should not be shared. The confidentiality covers also the entire process of the mediation, but also the outcome, the fact if the parties had a settlement or if they didn't reach a settlement, or any other opinion, suggestion, or expressed during the process of the mediation. So based on this duty, let us now see which are the skills that relate to this duty of confidentiality. So the duty, this duty of confidentiality is connected, we could say that's connected to the two following skills. First of all, it's the ability of the mediator to gain parties' trust towards, first of all, himself or herself, and of course, towards the mediation process. So the mediator must remind to the parties at the beginning and at the end of every session with the parties that the principle of confidentiality covers this process and therefore it should be always respected. Secondly, the confidentiality relates to the skill of the mediator, the ability of the mediator to manage efficiently the process. What does this mean concretely? This means that the mediator has to proceed with the process. The mediator has to discover common ground in the process towards settlement, even in the case in which the parties, due to confidentiality, they authorize the sharing only of limited information. So they say, I don't want you to share this with the other party. I just want you to say, not to say A, B, C, and D. I just want you to share the A elements. So in that case, this can be very challenging for the mediator. And why this can be very challenging? Because it's, if the messages to be transmitted from one party to the other are limited, then the process may be delayed. And the mediator, it can be more challenging for the mediator to discover the common ground and discuss with the parties on these common grounds. So the mediator should be conscious of that and efficiently manage the process even with limited transmission of information. Impartiality and independence. Let's start with impartiality. The duty of impartiality is described in the European Code of Conduct for Mediators, but also included in our rules, in the EUIPO mediation rules. Mediators must always act with impartiality towards the parties and be committed to serve all parties equally with respect to the process of mediation. So regarding impartiality, in order to ensure inclusivity, mediators should be attentive, should pay attention to ensure that all parties have equal opportunity to participate in the process. And the mediator should demonstrate neutrality, he should be neutral, and of course, equal treatment towards the parties. It is also important to recognize and handle any issues of discrimination during the mediation. In case of bias or discrimination attitudes from one party to the other, the mediator should immediately react, making it clear that during this process of mediation, this type of behaviors will not be accepted. regarding his own behavior, a mediator should also try to monitor and make sure that everyone has an equal chance to be heard and express their opinion. Avoiding assumptions can also protect the mediator against biases, because also unconsciously the mediator may also have biases, and this is unconscious biases. It's an element of the human nature. So he should avoid assumptions and avoid going into quick conclusions, and therefore avoid his own unconscious biases. Since biases may even be unconscious, the work of the mediator against them should be constant through continuous exercise of self-awareness and improvement in order to control them even better. Independence. This is a duty, a continuing duty throughout the process of mediation. So the mediator must disclose circumstances such as personal or business relationship with one or two or more of the parties, any financial or other interest to the case, and if he has previous links as a legal consultant or in another counseling capacity with one of the parties. This is a duty that is also described in the European Code for Conduct and also in the EUIPO mediation rules. Of course, if despite the fact that the mediator has declared this conflict of interest and still the parties would like to keep this specific mediator, it's up to the parties to say, we don't really care, we accept even this case of conflict of interest, and you can continue. In that case, the mediator may continue and he or she is not disqualified from the case. Just to have a quick look on our rules, or the EUIPO rules, this duty, as I said, comes throughout the process before accepting them to mediate, during the process, but also in the future. So if there is a case of conflict of interest, this should be declared, and the mediator should not accept the case if there is personal interest or involved in the case before, but also in the future. The mediator should not be, once the mediator has handled the case and the mediation has finished, the mediator should not be further involved in any proceedings that may take place before the EUIPO. So let us now again go through the skills that are needed for the mediator and relate to this duty of independence. The mediator should be transparent in case there is a previous link with one of the parties. It is up to the parties to say that we continue with this specific mediator in case there is a previous link, or we do not want to continue. Transparency constitutes a significant factor for the development of what we call the rapport between the mediator and the parties, this flow of trust. So the rapport is an essential component of a successful mediation process. The quicker the rapport can be established, the quicker the mediation can start to work out for all parties, building rapport. So this is because building rapport is the first step towards developing trust to the process. And not only the process, of course, but also to the face of the mediator. So the parties feel confident in that case that the process is fair and the mediator is transparent. And of course, that opens the way more easily to settlement. Flexibility and objectivity. The process of mediation differs from the litigation also in the sense, there are many differences, of course, but also in the sense that in the mediation, there are no strict procedural rules. As it has been already mentioned in our workshop, the manager of this process that is flexible is, of course, the mediator. So that means concretely that while it's the parties that decide the outcome, of course, of the mediation, while the parties decide the outcome, it's the mediator as a process manager of this process that decides on the next step, on the next steps regarding the process. So it's the mediator that will decide whether he may hear or she may hear the parties separately with the separate bilateral meetings, or he will advance with the process with a joint meeting, or who is going to talk first, or for how long each party will talk, etc. So, for example, regarding joint meetings, a mediator may decide that a joint meeting should be organized for one party, for example, to provide explanation or apology to the other party, or to exchange the parties to exchange information on a specific issue, on a specific aspect, or also to finalize a deal. So based on that, a particular skill of the mediator is to effectively and strategically manage the discussion towards the objective of the settlement. The choices the mediator makes during the mediation process, for example, if he chooses to go to a bilateral with one party, a bilateral meeting with one party, or he chooses at a certain point to organize a joint meeting, these choices are very important and they may have direct impact to the outcome of the mediation. So the mediator should have a specific strategy on deciding what he's going to do next in the process. For example, depending on the course of the context of the mediation, old business partners that are now in a dispute could be put together face-to-face without the presence of the lawyers. We will come back to that in a case study that we will see in the next presentation. So face-to-face, the old business partners that are now in conflict without lawyers, in order to work out better any points of conflict that they might have. Again, this is a choice, a strategic choice of mediator, how he would like to handle the process and how the process will be implemented during the day. So the mediator should orient these procedural choices towards the goal, of course, which is the settlement. This is very challenging because it is very easy to enter into eternal discussions, and therefore the mediator should always keep focusing on his final target, which is the way to reach, assisting parties to reach a settlement. Objectivity. However, the flexibility of the process is flexible, no strict procedural rules, but that doesn't mean that the process should not be fair and objective. So the mediator should ensure that all parties understand the characteristics of the mediation, the process, the role, the process itself, the role of the mediator, and also their own role in this process. Also, he or she should ensure that all parties have adequate opportunities to be involved. The mediator must not, in case of power imbalances, a weaker party, a stronger party, the mediator must not rebalance the power between the parties, in the sense of, let's say, reducing the power, trying to reduce the power of the stronger party and favoring the weaker one. This is not the objective. The objective here, while handling the power imbalance, is to ensure that parties have enough power to make informed decisions about whether and how to resolve their differences. In other words, mediator must ensure through the procedural choices that he makes throughout the process that all parties are able to self-determinate, to express themselves and self-determinate as far as it concerns as far as the outcome of the process is concerned. In that way, the mediator ensures that parties trust the process, as well as that the parties are satisfied in case of with the solution given in case of a settlement. Having said that, the mediator should be very, very cautious of his, of her, or her procedural interventions, because, of course, of the impact that these interventions might have on the outcome of the mediation. So these interventions to ensure that there is no power imbalance should be done only when the stronger party indeed exercises this power. So the stronger party tries to impose themselves to the decisions and the way the weaker party tries to resolve the differences. And of course, only the mediator should only try to control this power imbalance in the objective of assisting the expression of interest also of the weaker party towards the settlement. Active listening and open-ended question. Active listening means giving space and time to the parties to express themselves. It also means that the mediator understands what the parties say. The parties need to feel that they are being truly heard and truly understood. This way, rapport and also, of course, trust are developed between the parties and the mediator. This active listening can be done even through non-verbal communication, meaning nodding or the general body language of the mediator, or even using the power of silence. The mediator also may challenge the parties through reality testing. Reality testing is an exercise in which the parties identify themselves through discussion with the mediator, and they identify the risks and the weaknesses of their case. For example, the mediator could ask a party, could challenge the party by asking, what do you think that the court will, in case you go to litigation, would think about this element? Do you think that this element will be perceived as positive or negative by the court? In order to put the accent into help the party understand the strengths and the weaknesses of their case. Or, for example, what is the average of amount of damages paid in these cases? This is a question that we ask if the amount requested is really high, so that the party can understand by itself that maybe he's a lot higher than the average type of damages paid in these cases. Of course, being an expert in intellectual property helps the mediator ask the right questions and effectively challenging the party's position and helping the party understand the strengths and the weaknesses of their case. So if the reality testing is tactful and effective, it will deflate possible high expectations of the parties and therefore create an environment more conducive to a settlement. Through active listening and appropriate questions, the mediator will discover what is behind the surface of the conflict. The mediator should look for interests behind parties' positions and strategies. That means that he needs to explore why a party wants something, or why a party says something, or why a party insists on a specific position. So unmasking all these interests and needs behind the party's position can be done through exploration by asking this type of open-ended question. Why do you want to sell? What was your relationship, for example, with the other party in the past? What if no settlement is reached today, etc. So questions starting by why, what if, open-ended questions. The mediator, therefore, should look for deeper business or personal needs, experiences, values, assumptions, etc. it is through this exploration that impasses and deadlocks can turn into grounds for discussion and possibly settlement. We need to keep in mind that even behind incompatible positions, there may be found, we may find and reveal compatible interests. Therefore, if we would like to synthesize, we could say that the mediator should have the skills to listen, to understand, to challenge when necessary, to spot any restriction of the flow of information from one party to the other, and in that way open clogged communication channels between the parties and find new ground for discussion. Understanding human and business psychology. Mediator should conduct the process having in mind that feelings are as legitimate as interests and needs. It is not, it is wrongly considered, it's not true what is considered that IP disputes do not involve emotions. Of course, IP disputes, any type of conflict may involve emotions, and IP disputes are not the exception. So handling emotions is also a key issue for the mediator in IP cases. So the mediator should recognize emotions caused, for example, by previous highly charged exchanges between the parties. And these emotions, he may try to neutralize. For example, it is recommended for the mediator to use what is called normalizing statement, as well as normalizing statements. For example, saying to the parties that disagreeing and being angry is normal in a context of a dispute. So through considering that disagreeing and having different views, expressing different views is normal in case of a dispute, parties do not lose hope for a final settlement. Also, it is recommended to use statements in which the negative connotation is stripped off in order to have a clear message without it being colored by different emotions that the party explain, and convey it like this to the other party, neutral from without it being colored by emotions. Mediator should also emphasize the need, should also conduct a mediation that is forward, with a forward-looking perspective, looking towards the future. So he should or she should explore the possibilities of expansion of the value of the issues involved in the mediation. So expansion of value can be done through exploration, for example, of future business possibilities of cooperation between the parties, or a risk possibility of risk transfer, so providing warranty or indemnity, etc., or apology, expression of regret, and other aspects that are not necessarily financial aspects, but are aspects that really matter to the parties. So these aspects should also be explored by the mediator. Overall, the mediator, of course, should adopt a positive attitude, because this positive attitude, being positive, also creates a mirroring effect to the parties. So it is most likely that the parties, if the mediator is positive, they will also align to this behavior, and they will also be start behaving positively, adopt a positive attitude towards the dispute. So with this positive behavior, the mediator helps the parties to be tough on the problem rather than being tough with each other. And the last important element here is, of course, the continuation and further development of learning and training. So the mediator should not only be well trained, but they also should continue to further develop their skills. Of course, mediators should be competent and knowledgeable in the process of mediation, and this can be assessed through commonly accepted standards or through accreditation offered by recognized institutions. Furthermore, they should keep updated and informed by sharing experience with their peers and attending, of course, coaching and training sessions. It is important to say that this duty of keeping up and being updated, etc., is also included in the European Code of Conduct for Mediators, but also in our EUIPO mediation rules. I will just give you an example, our internal example of continuous learning and training path that the EUIPO mediators follow. So the EUIPO Boards of Appeal have been offering mediation since 2011, and ever since the office has been engaged in providing mediation training to its IP experts to obtain and enhance, further develop their mediation skills. So all EUIPO mediators receive special accreditation training. So first of all, they become accredited mediators. Then they have access to webinars and video sessions. They participate twice a year in mock mediations where a live case scenario is being used. Of course, there are additional external trainings in which they participate. And there is also, we organize mediation coordination meetings where they can share their practices and ensure consistency in their practices, but also share lessons learned. And there is also, of course, a monthly communication for mediation in order to update them in issues that may, global trends and other issues that may happen universally in the field of mediation. And this brings me to the end of my presentation. Thank you very much.
Yes, thank you very much, Natalia, for sharing with us in very details the attitudes and skill needed for IP mediators. We have received some questions from the audience, and I would like to invite you to answer these questions. We have 3 questions now, so I will read the first one. You already mentioned about the attitudes and skill required for IP mediators. How about qualifications needed for IP mediators? Can you have to clarify on this point?
Yes, it was the last part that I will speak from the EUIPO part, of course. So for the internal staff of EUIPO, first of all, the mediator should be accredited. It's all of the staff that goes through this accreditation, they are IP expert staff already, and that go through this accreditation given by recognized institutions such as CDR or CR. And then we have this continuous and training pathway that I just explained. So they still not only participate to mediations, but they also we try to keep them updated through all these trainings, internal trainings, mock mediation, external trainings, etc. So specifically for qualification, I would say that for EUIPO, for somebody to become an accredited mediator, first of all, it has to be an IP expert, and on the other has an IP background, and secondly, to go through the accreditation, given the accreditation training by recognized institutions.
Yes, thank you, Natalia. The second question is, can claim or discovery of non-impartiality or conflict of interest of the mediators be used to invalidate the signed agreement following the mediations?
I would say yes, but it's because there is already, I think Alexandra raised maybe she already faced this I don't know, she has more experience in that. I would say that in any case, there is a mediation agreement that is signed at the beginning, which is the agreement of the parties to enter the discussions. So I would say yes, but I would prefer to leave Alexandra to give feedback on this.
Yes, Alessandra, please go ahead. Thank you for joining us for this Q&A.
Good morning from here. Good afternoon to you. And thank you very much for having me again on this last workshop. I'm very happy to be here. This is quite an interesting question. And luckily, no, it has never happened to me that there was a conflict of non-impartiality. And actually, I'm not aware of it ever having happened here at the office, that there was a conflict of interest of the mediator. Now, the first thing that I'd like to say in relation to this question is that obviously if there is a conflict of interest for the mediator who is bound by the rules of mediation, as Natalia has very well explained at all levels, would have immediately declined the job of being a mediator in this case, right? So I guess that it is a case which is very, very rare. Even so, if the parties would claim this, the agreement they have signed would still be an agreement between the parties, which is ruled by the law that the parties have put into the agreement. So the parties will agree on having the agreement ruled by, I don't know, the law of Singapore, the EU arbitration of EUIPO. So the parties, like in any other agreement between two companies, will have stipulated in accordance to which law the agreement is signed. They would have to look into this. I don't think that an agreement which is voluntarily signed by two parties in perfect knowledge of the law, in assistance of the lawyers, can be invalidated by principle on the grounds of an impartiality of the mediator. The mediator does not give any binding advice. Does not give any advice per se. Let's recall that a mediator is a mere facilitator to help the parties on a voluntary basis to reach an agreement. So the agreement has been signed by the parties. So it is independent in that sense from the mediator. I hope to have answered the question.
Thank you, Alessandra and Natalia. The last question that we received, and I would like to invite both Alessandra and Natalia, if you could have to answer these long questions. Is it fundamental that mediator must declare if he has any prior engagement with one of the parties and his non-disclosure is not compliant with the usual requirement? But if this led to a settlement agreement signed by both parties and later one party wants to repudiate the agreement on the ground of non-disclosure, I do not think this should be allowed in the absence of any clarity bias by the mediators. What is the position in EUIPO or the member state court to this issue?
I think it's the same question asked in a different way. Again, it's very important to look what Alexandra said to the applicable law of the. It may be the case, it may not be the case. I suppose it depends on the national law, but at the end of the day, the mediation agreement, the beginning, is signed by parties and the mediator, meaning the agreement to enter the mediation. So in that sense, the mediator is obliged to declare any conflict of interest. On the other hand, the settlement agreement is only signed by the parties, as Alexandra mentioned. So this is a voluntary agreement. If there could be something in the national law applied in this agreement that could be invoked in order to bring into the game this let's say this objection that the mediator was biased. But again, it's a question of the specific context, I would say.
If I may chime in, here at EUIPO, since this has been specifically asked in this question, we are very, very strict on this issue. As you know from Natalia's presentation, and from yesterday as well, we are mediators within the EUIPO for the time being. This is how we are managing our ADR service with mediators who at the same time work actively at EUIPO. For instance, I am also a decision writer in the boards of appeal, so I draft decisions. Now, we keep it very, very strict that the mediator of a case cannot be involved or have been involved in the past in the process of the application of the trademarks at issue, in the process of possible opposition proceedings, or even less before the appeal. So the mediator in charge of the case will have had no relation whatsoever with the case. This is why we also have an ADR service who verifies, because obviously everything is recorded as in what we do at the EUIPO, you can trace it. So the service would be very strict in verifying, and as I said before, the mediator would immediately decline the engagement of being a mediator in a case where he or she has been previously involved, and even more so if there is any personal relationship to one of the parties. That is unacceptable, and it would lead to the immediate seizing of the mediator at EUIPO.
Just to add to what Alexandra said, as I went through my presentation, the European Code of Conduct for Mediators establishes already this duty. But the European Code of Conduct sets the minimum. So us in EUIPO, we took the minimum and we just raised even more the standard. So our rules go even further than the rules of the European Code of Conduct. So it's, as Alexandra mentioned, the standard is set very, very high. So and the rules are very strict in that sense.
Yes. Thank you very much, Natalia and Alessandra, for your contribution.